Rasco. I'm thrilled to see all of you here with us tonight. Like I said, it is in the holidays, so this takes a real commitment from all of you to say that you're going to come learn something that you're going to be able to use for not only yourself, but for your homeowners association and your community as well. I am the executive director of Neighborhood Alliance of Central Oklahoma. That may be new to some of you. A few of you I recognize on the screen, but this is one of our first workshops for the Norman area. Neighborhood Alliance is a new contractor with the city of Norman. The city of Norman recently gave a contract to us to be able to come in and provide workshops and support for neighborhoods in the Norman area, just like we've been doing in the city of Oklahoma City for over 45 years. I've been with the organization for 20 years. I've got Ana Herrera Dangy with me on tonight's show with us as well, or tonight's workshop. And she has been with us for about 8 years now. We have a staff of 6 people. We are in the process of hiring someone that will specifically be for the Norman area. We have not found the exact right person for you yet, but we are looking for a neighborhood coordinator that will work for us, that will be housed in Norman, actually live in Norman. That's one of the criteria for the job. And they will be the Norman coordinator for the Norman Neighborhoods Project that will continue to support Norman neighborhoods and offer workshops like this, not only for mandatory neighborhoods like yours, but also for voluntary neighborhoods as well. And that's because your city believes strongly in the power of grassroots neighborhoods. It is a contract which that they've done through us. So it is not, the city staff is not running the program. Neighborhood Alliance, which is a private nonprofit, will be running the program. So it gives it some autonomy. We will be able to run the program through Neighborhood Alliance with your input as neighbors, so that we can have some input as to how you want to run your neighborhoods and help make Norman even stronger. As I think all of you know, every city is as strong as its neighborhoods. So we welcome you. We're very, very excited that you're here tonight to learn even more about how to make strong homeowner associations. Tonight's workshop is sponsored by CIT, and Patrick McClanahan is here to tell you a little bit about his bank. He is a vice president with CIT, and he has helped sponsor these workshops to help bring them to you. And then once we hear from Patrick, I'll introduce your speaker for the evening. Patrick, do you want to tell us a little bit about you and your bank and what you have to offer to the homeowner associations in Norman?
Yes, yeah, thank you so much for that wonderful introduction, and being part of the foundation of the start of a wonderful events and education here down in Norman. I really appreciate this opportunity. So my name is Patrick McClanahan, and I work for CIT, and a specific division of CIT called CAB, and that stands for Community Association Banking. And what that is, and I know you'll probably be all surprised, is that we focus just on homeowner associations and management companies that handle the receivables and payables. So we have treasury services and programs focused on that. And then we loan HOA money when they're short on projects like roads or buildings, pools, things like that. So that's kind of the summary. I've got a little slideshow. And I guess if you can go ahead and click, that's a little bit about myself. I've been doing this for 11 years. I couldn't believe I started adding up the time. And so I actually live in Lake St. Louis, Missouri, and I cover all those states, if you can see there, which is something pretty amazing. I kind of say I cover a lot of cornfield, cattle field, and the field of dreams. There's all in between. So I cover the Midwest and just love what I do. And I help board members with education and sponsors events with Matthew here in Oklahoma. I've been doing that for, I think, for 4 years, I guess. So I'm real excited to get going on this one this year and next year as well. So the next slide is just really a video, just kind of a summarizing what I just got through talking about. So go ahead and see if that, hopefully you guys can hear the audio. And some fancy music there. Kind of like, I feel like I'm in a jazz band or something. So, hey, there's my contact information, my email address and my phone number. You can call me and email me with any questions. And basically what I want to make sure you understand is, if you've got a project coming up in the next year or two, give me a call. We finance those when you're short on your reserves, and I'll walk you through the process, work with Matthew. We asked for his opinion letter, and so we work together to help you guys get what you want accomplished. So I appreciate your time, and I'll let Matthew take it over. Unless there's any questions, you guys got any exciting banking questions? Yeah. Okay. All right. No worries.
Actually, I'm going to take it over before Matthew does, but thank you so much, Patrick.
Okay.
I really,
all right, you're welcome.
I hope all of you, even if you just have questions about how to use an out-of-state bank, definitely talk to Patrick, because lots of local HOAs have utilized him and have been very, very happy with that. I'm proud to introduce our speaker for the evening. It's Matthew Winton. He's a local attorney, but he is our the person who knows everything there is to know about HOA law. He specializes in homeowner associations, condominiums, and things, townhome associations. He is one of the very few, if not one of the only attorneys in Oklahoma that is his specialty. So we are pleased that he has been doing these legal issues workshops for us for, I think, 14 years now, in a partnership with Neighborhood Alliance. He does these free of charge for us, so that you as HOA members can get to know the correct answers according to Oklahoma state statutes and the best practices. So here to hear from the best is Matthew Winton on legal issues for homeowner associations. Thank you, Matthew. It's all yours.
All right, my pleasure. Thank you for that great introduction. I appreciate that, Georgie. And Patrick, it's good to see you. Patrick and I have worked on these legal issues seminars for several years now. And in fact, I think 2017, we did a fraud and embezzlement program together. And so I appreciate the long relationship that I've had with Patrick. So if you're not familiar with this program or the format, what we'll do is work through a bunch of slides that I've prepared. And as we go along, if you'll use the chat feature to type a question, if you have a comment, this is designed to be interactive. And I'm happy to sit here and talk for an hour and 45 minutes if that's what we want, but it's really designed to answer questions that you might have. Can't give you legal advice. In fact, I'm going to put my slides up and we'll start going through those. That's my contact information. I believe Neighborhood Alliance makes these slides available for download. I will also make them available. Not sure why. All right. So This is a disclaimer. It just says that I'm not representing anyone as an attorney, neither is my firm. I'm not going to give you legal advice. I'm not going to take clients. That's not the purpose of this seminar. The purpose is for me to provide some basic HOA law and information that I feel it's important that everyone know and understand. And I will try to answer your questions, but if you ask me a specific legal question, well, we have this person who's violating our covenants. Can we enforce our covenants against them? That's a natural, normal question. I'm just not going to say specifically, yes, you can enforce your covenants, because I haven't read them. We will talk in generalities. As hopefully you know, the application of the law is highly dependent on facts. And that's why I can't give you a legal opinion that you'll rely on tonight. This is some additional resources, and I started to say I'll put the slides up. So this okhoa.blogs.com, this is a blog that I host, and I'll put not only this video from tonight, but also the slides that we're going to go over on here. I also put a lot of videos free of charge on a YouTube channel. It is not fancy. It is not going to wow you with really nice music in the background or videos. It's pretty much this, me sitting here talking about HOA and condo issues. So it's not designed to wow you in production quality, but it is a lot of information. And then there's my firm website. And of course, like everybody else, we have a Facebook. All right, so enough of all of that. Let's get into the interesting stuff, or what I think is interesting, because this is what I do for a living. So we want to start with the beginning. When I have people come and want me to answer a question for them or take a look at various issues going on in their neighborhood, the very first thing I do, and the very first thing that I encourage board members to do, is create a governing documents file. You know, if you're going to go on a journey, some people, I am not one of them, may just get on the road and take off. I want a roadmap. I want to know where I'm going to eat, where I'm going to sleep, what gas stations are available, what things to see. I want to enjoy the trip and not have the anxiety of, okay, I don't want to figure it out. I'm not a contemporaneous, figure it out kind of person. It's kind of the same way with our covenants and our governing documents. And so what are those documents that we're talking about with mandatory community associations, whether it's a homeowners association or a condo association? Well, the very first document, if it's a homeowners association, we're going to look for is a plat. Now, a plat, I'll show you a picture. A plat looks like this. A plat is a legal description. There's state statutes that tell us exactly what has to be in a plat or on a plat. Interestingly enough, different municipalities want to see more detail. Some want to see less detail. One of the things peculiar or individual to the city of Norman is they're very particular about making sure that there's access to either a public road, or they want to make it abundantly clear what the access is. And so sometimes with plats in Norman, you'll see these long slivers of land from a lot going out to a road. And that's because the city of Norman requires that. City of Norman too has a very unique ordinance. I'm not aware of any municipality in the state of Oklahoma that has an ordinance like the city of Norman that requires certain specifics when it comes time to develop or transition. We're not going to talk about that tonight. We will talk about that more in detail in part 2, because if we're going to talk about HOA issues in the city of Norman or in Cleveland County, we've got to talk about this city ordinance. So we'll talk about that next week. But the development process typically starts with a plat, and then usually right after the filing of the plat, we'll have a declaration of covenants. Now, this is where terminology really makes no difference. You may see a document called an owner certificate. It may be called a declaration of property owners association, maybe called declaration of covenants, conditions, or restrictions. It doesn't matter what it's called. What we're looking for is a document that's recorded with Cleveland County Clerk's Office, not court clerk's office, but the Cleveland County Clerk's Office, that is recorded against all of the property that's in that plat, that says what we can and what we can't do with our property. So a lot of times a set of covenants will tell us, can I use my property for short-term leasing purposes? In other words, can I Airbnb or VRBO my property? Can I have a long-term leasing arrangement with a tenant for my property? Can I use my property for commercial purposes, or is it residential only? So if I have a business that I want to run out of my house, like a daycare, like a beauty shop, anything like that, will my covenants allow me? I have a case in Cleveland County right now where an individual on a larger acre tract in a platted neighborhood that has covenants and a homeowners association decided they wanted to start a medical marijuana grow operation. Well, the question in that case is that a commercial use of the property? And so knowing those things before we start making those uses is important. And the covenants answer that question for us. Now, sometimes as we go down this list, we'll find a set of bylaws attached to the covenants. You don't have to file bylaws, but oftentimes we will, just so that we have those of record when people take title to the property. Now, the certificate of incorporation, articles of incorporation, it's very common, and in fact, highly recommended that our community associations be incorporated. And the articles of incorporation are filed with the Secretary of State's office, the Oklahoma Secretary of State, and that's what creates the corporate entity, the corporate existence of our community association. You can have an unincorporated association, but Patrick isn't going to lend you money if you're an unincorporated association. Insurance companies are likely not going to insure any of your common elements. And hopefully every attorney who you ask their opinion is going to tell you it's the worst possible form of operation for community associations. It's very inexpensive, very easy to incorporate, and there's really good reasons under the law to do so. The other documents that we might find in a community association context are corporate resolutions, rules and regulations, minutes, things like that document the corporate business goings on, decisions, things that we might want to look back in the corporate record and find how a board made a decision, why they made a decision, what that decision was. That's the primary purpose of minutes, is to give us a record of the decision-making process. So I started by saying, whatever the question is, I want to start with a full, complete governing documents file, and I encourage board members to do this. So this is a very simple thing to do, is you do the research, or you hire someone to do the research, but however you do it, you get a complete governing document set, 3-hole punch them or scan them in, put them on a folder, but each board member needs to have their own set. And what I suggest is the board member take a weekend, go through with a highlighter, and primarily in the declaration and in the bylaws, not so much in the articles, but possibly in the articles, but go through the governing documents and highlight the word shall, S-H-A-L-L, every shall that you come across, I want you to highlight it. And that's going to tell you what must be done. So whether it's statutes or contracts, which covenants are considered a type of contract, if we come across the word shall, it's considered non-delegable or non-discretionary. In other words, shall means you have to do it. And words like will or should or ought or may, those are all discretionary. So if we come across a provision that says, for example, the board shall establish a reserve fund, and then goes on to talk about what that reserve fund looks like, we don't have the discretion to say, well, we don't really need a reserve fund. If it says shall, that's non-discretionary. And if we don't want to do it, well, then maybe we want to take that shall out of the governing documents and replace it with a may and put some discretion into them. All right. So having a good governing documents set file, that's a good starting point, right? We looked at the plat. Let's talk a little bit about the development process, because a lot of questions are answered with a clear, straightforward, by the book development process. And questions that I'm thinking of are, well, is my lot part of the mandatory association or not? Are the common areas, what are the common areas? Is the brick fence that goes around the neighborhood, is that common area? Does that belong to the individual lot owners? So typically we try to anticipate and answer all of those questions in the development process. Now, I usually come in with a developer client after they've obtained their zoning, after they own the property, and right around the time where they're going to file the plat. And so around that time where we have final approval, or we're heading towards final approval for the plat, we'll get the association incorporated, or whether it's an HOA or a condo. By the way, if I'm using the term HOA, I'm using it for an abbreviation of homeowners association. And you won't find that term homeowners association in Oklahoma statutes. You'll find an owners association. You'll find it referred to as a residential development association. You won't find the word condo in the Oklahoma statutes either. What you'll find is the term Unit Ownership Estate Act. Now, who wants to say that over and over again? So we just say condo. It's the same thing. That's how you know whether you own a condo unit or a home in an HOA, is if you look at your declaration, usually at the very top, it will tell us whether this is a unit ownership estate or a condominium, or whether it's a real estate development homeowners association. All right, see a couple of chats. Okay, one of the question came in.
Sorry, Matthew, I answered one of them for you.
Oh, not a problem. Yep, we will cover amendments in part 2. So on the development process, the HOA is often incorporated before we file the plat, before any lots are transferred. Now, whether it's done then or later is kind of immaterial to me, but it's just important that there is an incorporation document filed. So one of the most crucial things in the development process that cures a whole lot of headaches that could potentially arise is as soon as the plat gets filed, we file the covenants. The same day, the next day, it could be a year, but what we can't do is sell any lots between the filing of the plat and the covenants being filed. Because what happens is only the lot owner can file those original covenants against the lots. And we want all of those lots to be owned by the developer. And if the developer gets antsy and sells them off to a lot or two to someone else, those lots aren't going to be subject to the covenants unless that lot owner approves in writing, a notarized signature, approves those covenants. Call it, letting a horse out of the barn or whatever. It's a bad day. And the last thing we want to find is that, well, we've got to go to a homeowner and ask their permission to file these covenants. You can imagine how that conversation typically goes. There are ways of curing it, but the best cure is to not get sick in the first place, right? Avoid it at all costs. So that's something that we pay really close attention to. Another thing in the development process that I think it's misunderstood. I spend a lot of time going to what are called transition meetings. And I hear all kinds of statements. I hear all kinds of nasty things said about my developer clients. I understand the differences in perspective between resident owners and the developer. I think one of the things that the city of Norman has tried to do with the ordinance that I referred to earlier is to try to address this issue, the sometimes contentious, but it absolutely does not have to be contentious, period of time between when the developer is almost done with the development process and selling all their lots, and we have this handover of control of the community association to the resident owners. I have developer clients that do a really good job of this. And what I mean by do a really good job is they communicate early, they communicate often, they collect assessments from the very beginning and have an account of HOA funds that these individuals take over so that it's not starting from zero. And at those meetings, I see a dramatic difference in the willingness of the resident owners to elect their board. It's more of okay, passing the baton kind of event, as opposed to this butting of heads and, well, you have to do this before we will take it over. And we spend time going over, well, you took over the association when you bought a lot in a neighborhood with a mandatory association. There's not this developer, you do this before we will take it over. But there's this idea that's out there, and if we're having that conversation, maybe we could have done a little bit better job on the front end of involving the resident owners, getting them lined up for transition. But really the whole transition is simply the election of a corporate board for the association. It makes no difference whether the association holds title to the common area, because a lot of times we're ready to transition control of the board before the common areas are completed. And that doesn't mean that the resident owners can't oversee and administer the corporate existence of the association while the developer or builder finishes common area. But there's a conception out there that, well, it all has to be buttoned up, the roads have to be perfect, and we're not going to take it over until you do this. So a lot of times transition, we can avoid some of the bumpiness with a good development process. And then ultimately, there's going to be a transfer of common areas and common elements to the association because that's what they're designed for. Common areas are oftentimes recreational facilities or amenities, clubhouse, swimming pool, sport courts, things like that. A lot of times the common areas are drainage easements or drainage areas, such as a detention or a retention pond. Now, these are there not because a developer wants them or because resident owners want them. It's because the municipality has required detention and retention facilities to be put in. Otherwise, they wouldn't approve the plat. Now, what these do is they, based on an engineering calculation, they take the stormwater runoff that normally would have perked or followed the contours of the land where there were no houses and where there were no concrete driveways or asphalt roads. And we've changed how the land deals with water in every single development. Well, when that happens, part of the development process is we figure out, okay, well, what are we going to do with that water? That's drainage, drainage easements, and detention retention. So as a practice, most municipalities, almost all municipalities, offload the oversight of that drainage, that surface water drainage, to community associations. And some associations, that's their primary purpose, is at least on paper, is to manage this stormwater. While I'm mentioning it, if someone were to ask me what I think the primary purpose of a community association is, the very number one purpose of a community association is to promote community. And that's not being cute or simplistic. We can go into detail a little bit later what I mean by that, but every association, mandatory association, has these various business functions, whether it's maintaining the common area, collecting assessments, operating like a small business. But those are all, in my mind, ancillary to the primary purpose of a board brainstorming, daydreaming, whatever you want to call it. Strategic planning, I guess, is the official leadership phrase for it. But how are they creating, fostering, promoting community within that neighborhood? What are they doing to help resolve conflict or minimize conflict? What are they doing to help people when they get off work, when they're ready to decompress, that when they drive into the neighborhood, it's just almost a release. I am so happy that I am in this neighborhood. Now, that's a tall order, and it's tough to do that when people are blowing you up on Twitter and Facebook, and when someone paints their house a crazy color and you have to deal with that. I understand. We deal with all of those issues for our clients, but keeping in mind that the board's overarching purpose, even in enforcement, even in collections, is how do we make this place a home? That's job one. Okay, so, all right, I want to talk just a little bit about what's the law, and kind of using some of my comments on transition. I hear this a lot where I'm at a transition meeting, I'm discussing the layout of the development, the governing documents, I'm answering questions about, well, what does a board member do? And then I hear someone say, well, I've read that transition has to happen or can only happen when 75% of the lots have been sold. And I understand that. There are some states where that is the law, that transition happens at 75% or a certain percentage. That's not the law in Oklahoma. In fact, in Oklahoma, there is zero law on what we call transition, okay? And so I think this is why, too, we see some developers thinking ahead and what this looks like and kind of forecasting and trying to assist resident owners with that transition period. And then others, it's just not on the radar because the law doesn't say it has to be on the radar. But when we talk about the law, what is it? Where would we find it? What does it look like? How do we apply it? So answer that with this slide. There's not a whole lot of law in Oklahoma. Georgie said we've been doing this about 14 years. I think that's right. It's somewhere around there. It's well over a decade. And the law in Oklahoma for condominiums, at least as statutes go, it hasn't changed at all. And in fact, our Condo Act was passed in the late 60s and has never been amended. It's never been updated. So what we had at the outset for condominiums is exactly what we have now. The HOA Act, which is not called the HOA Act, but in the statute, if you go to the statute, you'll find it called the Real Estate Development Act. We call it REDA, Real Estate Development Act. This one has only been updated a couple of times. Once to make sure that Oklahoma followed what was already the law at the federal level regarding flying the American flag. It was a feel-good statute adopted by the legislature a few years ago. And then some tinkering with section 857 with who has to provide a copy of the covenants at the time of closing. Other than that, the statute hasn't changed. It's bare bones. Both of them are bare bones. There's not a whole lot of guidance. And so what that means in Oklahoma, the law that we look at is, what do the covenants say? It's very, very important that we know what the covenants say and address, forecast, try to predict, okay, is there language in our covenants that we might need in the future that we might need to amend, to add, which is why one of the topics for these 4 hours that were 3.5, 4 hours that we'll spend over the next couple of evenings, one of the major topics is amending documents. So the law is the statutes, and then I also referenced the corporation code there, because like we said, all associations, whether they're condominium or homeowners associations, should be incorporated. No good reason to operate without it. If you're not familiar with OSCN, this is a free state courts network. You can do all the research into all Oklahoma law. You can also look at most of the lawsuits that have been litigated. You can search by party. You can search by case number, by date, by county. It's a really good resource for the law. I've got a slide on here about unincorporated associations. I'll leave it to you to read. I don't want to beat a dead horse, but I would never, ever live in a neighborhood that has an unincorporated association. I'll just paint a picture. It would be like taking money from your neighbors, putting in a common account under somebody's social security number because you don't have an EIN for an unincorporated association, and having personal liability with all of your neighbors for all of their acts or omissions. I mean, it's craziness to operate like that. So don't do it. Let's talk about meetings. And I'm not going to read this to you. I want to tell you, let me look at the time. Okay. And I think I said this, we looked at the chat feature. If you have a question, just hit the chat. I will try to watch and cover those as we go along. I don't think we have any pending. Patrick, the one about adding about VRBO, Airbnb, I don't know if you're just reiterating that, or did you want to jump in on that?
Well, I just wanted to, because I cover 8 states, and I'm on my board where I live, and we're amending our governing documents as we speak, just because they're quite old. But one of the things that's the trend in the industry across the nation is homeowners, it starts out in California where a homeowner decided to incorporate his property and then lists it as a timeshare and was selling timeshares based on so many months, and different people would come in and stay there at, say, this nice place. Maybe it's on the beach or in a golf community or whatever. But that's a trend that I wanted to share with you, that there is some legalese that needs to be placed in those to make them omitted so people can't incorporate their homes and start doing timeshares. Have you heard that yet?
I have not heard of people time sharing in Oklahoma. Haven't come across that.
Yeah.
Airbnb is the #1 covenant amendment project that I'm doing now, and has been probably for a year and a half, maybe 2 years.
Well, get ready. You got that lake, Grand Lake, that's pretty, popular, I would think. So could possibly have an area there.
Yeah, and boy, are we not ready to address timeshares, because there is no law, no statute regarding timeshares. If I remember correctly, timeshares are mentioned once in the Landlord-Tenant Act, saying that they're not subject to the Landlord-Tenant Act, just like condominium ownership is not. That's the only reference to timeshares. So in all of my developer covenants, we have that language that timeshares are absolutely prohibited. But we're going in and limiting short-term rentals on a lot of neighborhoods. Now, I haven't done the research. Actually, someone there might know this. Oklahoma City has an ordinance that requires a business license to home share. It makes it really easy within the Oklahoma City limits to address Airbnb timeshares, or excuse me, home shares. I don't know if the city of Norman has one of those or not. But in Oklahoma City, it's really easy. So if you have to get a commercial license to operate a business in your home, well, then you're violating the no business, no commercial covenant restriction that likely is filed against your property. And what's an interesting twist, if you are operating a home share and you haven't gotten the home share license, violation of an ordinance is a public nuisance, which also violates the covenants against a noxious or offensive or a nuisance activity. So in Oklahoma City, at least, you have to have covenants that allow it and a business license in order to operate an Airbnb. And I use Airbnbs. That's what we use when we travel quite often, and have had an Airbnb in Oklahoma County. There's a place for them. They're certainly great for our economy and an alternative for families and individuals and couples and everyone that is spending tourist and vacation dollars in a city. But it's kind of like the distinction between a commercial use and a residential use. There are areas where we want commercial uses and we don't mind them. And then there's other areas that we just want residential use. So you're exactly right, Patrick. That's a big issue. Haven't heard the timeshare one, but that's a slice that I'm sure we will experience. We seem to lag maybe about 20 years behind California on the real estate spectrum, but we'll see. All right, so let's talk about. Here's a comment. Okay, so Doug says Norman has a similar language for B&B. Okay, well then in Norman you have the tool to address, all right, are we going to allow Airbnbs? If so, we need to put the covenant language in place to govern that. Otherwise, if you have to get a commercial license in the city of Norman, then that's just like Oklahoma City. We've had Several of those lawsuits that we've represented associations been very successful in enforcing those. And that's usually what we find with covenant language is if you have the right tool, then you can enforce it and it makes your governance much easier. But if it's old language, if it's clunky, if it doesn't quite fit, it's like trying to screw in a Phillips head with a flathead. You can do it, but you're using the wrong tool. So for those of you who are mechanically inclined, no one screwdriver from the next. So let's talk about meetings. I'm not going to read this to you, but I'm going to tell you just kind of in bullet format some of my ideas or thoughts or approaches to meetings. If we know the meeting is going to be contentious, and usually we know the chatter starts on social media. If it's a special assessment meeting, usually people have strong feelings about increasing assessments. If we think that there is a legitimate, and I say legitimate, not that we want to have a uniform officer there to intimidate or throw some weight around, but if we think there's a legitimate issue of things getting out of hand, then having a uniformed officer there may not be a bad idea. I will tell you though, in 20 years of representing associations and spending hundreds of hours in association meetings, those instances are really few and far between. Okay. Most of the time, having a board who has clearly communicated what the purpose of the meeting is, using a chair of the meeting who is practiced in resolving or at least minimizing conflict. We have an agenda and we stick to the agenda. If we run our meetings professionally and not like a rodeo where you turn all the kids loose and the sheep's in the center with the ribbon on its tail. I mean, if we run these like a small business and with some professionalism, most of our meetings are going to go okay. But difficult conversations, handling conflict is difficult. If it wasn't, everybody would do it fantastically. So having someone who can handle people getting a little upset, maybe raising their voice and not responding in kind, again, practice at lessening conflict and not increasing it. That's who we want in charge of our meeting. Some of the other things that we can do, having the meeting in a church or some kind of religious setting. Not that these are religious meetings by any means, but most people, particularly in Oklahoma, I mean, we're in the Bible Belt, they recognize that you don't say certain words, you don't behave a certain way in various places. Now, I went for about 17 years of my practice where I could say I never had anyone drop an F-bomb or start cursing in a church sanctuary. I had an individual at a meeting a few years ago break that record. So I can't say that it won't happen. I can tell you that people are usually on their better behavior in church settings. One of my favorites, if I think we're going to have a really contentious meeting, well, I'll schedule it in an elementary school library and I'll make those people sit in those little bitty chairs at those little bitty tables. And it's hard to be a tough guy when you're sitting in a little bitty elementary school chair or in an elementary cafeteria. Maybe that's just me entertaining myself, but it seems to help, right? One of the things that comes up is the Open Meeting Act. I have board members email me. We have an owner on Facebook or sending emails saying we are not complying with the Open Meeting or the Open Records Act. Well, those don't apply in Oklahoma. There are other states that have pretty comprehensive books and records requirements for homeowners associations. Oklahoma does not, right? If you're incorporated, there are minimal requirements for record keeping. There are expansive records inspection and copying rights for members, but not the Open Meeting Act, right? One other thing that typically helps to keep meetings under control. I'm half deaf in one ear, and so when a bunch of people start talking, I can't hear anything anyway, and so it's a really good excuse to stop what's called crosstalk, where a person has the floor, usually in polite conversation. We wait till one person stops talking to start, someone else start talking. We usually wait, we raise our hands, we all understand that. That's another good reason to have it at a school, because we were all indoctrinated to raise our hand and then speak when we're called on. But sometimes people can't, they just can't contain themselves. And having someone running the meeting who can politely ask people, okay, understand you have a lot of thoughts and opinions and you're ready to share them, but we're going to talk one at a time. I will usually legitimately, and I'm not making it up, tell the group, I can't hear anything anyone's saying because it all sounds like noise because of Meniere's disease that I have. And if it becomes a problem, you can have people stand, come to a microphone, and just simply not recognize anyone who feels like they need to shout out from the audience. One of the things, and this isn't on the slide, one of the things that I've started doing in recent years, at the very beginning of the meeting, I don't really call them rules for the meeting because we don't really need rules, but I go over the expectations. And part of these expectations are, look, we're all neighbors here except for me. I don't live in your neighborhood. I'm getting paid to be here by whoever. But all of y'all are neighbors. At the end of this meeting, y'all are going to continue being neighbors. And one of the things that we do as neighbors is we watch the way we talk to one another online, in emails, and in these meetings. And this is something that I say at the beginning of the meeting. Basically, it's, look, folks, we're setting the expectation that we're going to talk to one another the way we want to be spoken to. Right now, maybe there's people out there that want to be called an idiot, but I'm not one of them. Right? I don't want to be called that. I don't think of myself like that, and so I don't want others calling me that. And I will reciprocate by, despite my personal thoughts and feelings over someone, I won't say that out loud. So we kind of set the ground rules, and I have been pleasantly surprised in a lot of meetings where I don't have to police it. If someone goes off the rails and they can't help themselves, their neighbors police it. They will, I'll start to hear grumblings around them and, comments like, why don't you be quiet and let, the other person talk, or, hey, that's unacceptable. It's very helpful when neighbors recognize and actually speak up and help you police. And one of the things that I've found that helps that is just say it out loud at the very beginning. Hey, folks, this isn't a YouTube video where we're going to start tearing each other apart about 3 or 4 comments in. This isn't a place for your biting wit or sarcasm. We're here to get some HOA business done. And on top of that, treat each other like neighbors that we literally are. Saying something along those lines is very helpful, I've found. All right, so that's the spiel on meetings. Let's talk about minutes for just a minute. Minutes are not a transcript. I frequently, too frequently, find that association secretaries are wearing themselves out by, one, attending 4-hour board meetings, which are way too long, but they're trying to be transcriptionists when all they need to do is take meeting minutes. Meeting minutes and resolutions really are simply a record of the decision making. It's not who said what, and this person had a good idea, and then that person had a comment and made this suggestion. Those aren't meeting minutes. That's a transcription. And as litigation counsel for associations, I don't want a transcription. A lot of times what we have is a video, and that's bad enough, particularly if it's my board or my clients who are doing the screaming and cursing. We want meeting minutes to just reflect, was there proper notice? Was there a motion? Was there a second? And was it passed? And then accurately reflect what that motion was. Resolution may go into a little more detail. Sometimes with resolutions, what we're doing is not just bulleting the decision and that it was adopted. We may be providing a little more information and maybe some guidance. So for example, if your association needs, say, a large amount of horticulture work done. So a few years ago, we had this horrible ice storm. It nuked a lot of people's trees. It created a lot of headache and expense for associations. And it may have given rise to a need to form a committee. There were a lot of associations that had significant expenses that they were looking at for tree cleanup. And maybe the board wanted to farm that decision out to a committee. So a lot of times what we'll do through resolutions is we'll say things like, whereas the association is facing a significant budget issue with this tree damage, whereas we feel as the board it's important to involve in the decision-making or the deliberation process selected owners with expertise or interest. Whereas we want to form a committee to research and explore and possibly identify a particular arborist or horticulture firm to give us an opinion on effective, cost-effective cleanup. And so what we're doing with this resolution is we're painting a picture of need, wants, and most importantly, what the scope of the discretion is in the committee. Is this committee tasked with entering into a contract as an agent for the association? Or are they simply fact-finding, information gathering, and reporting back to the board? And if so, if it's the latter, then we expressly state in the resolution that they have no decision-making, cannot enter into a contract, and have no agency on behalf of the association. So that's something that we'll typically do with resolutions, right? We could do that with a minute. That's a long motion. A lot of times we would write that kind of motion out, but resolution helps to keep track of all of that. So we don't have to rely on people's memory. Well, what was the purpose of that committee? How long were they supposed to last? All of that, okay? This slide deals with and assumes that the association is incorporated. A lot of times questions pop up like, can we use proxies? How many people do we count for quorum purposes? Do we use a majority vote? Do we use plurality versus cumulative voting? A lot of those corporate type questions, operational questions. Well, if our association is incorporated, then the Oklahoma Corporation Code provides some of those answers. And most of the statutory language says, unless otherwise provided in the certificate of incorporation or the bylaws, meaning, hey guys, if you don't have a governing document that answers this, then we will supply you an answer, right? The corporation code does a really good job of anticipating some of these gaps that we sometimes find in our corporate governance documents, and then providing us just enough to get the business or get the job done, right? Hopefully, though, we have a really good set of bylaws that answers a lot of these questions, including can we get a quorum without having to have a majority of a 400 unit neighborhood physically present in a meeting, which is never going to happen. Okay. It's difficult to get written proxies from a sufficient percentage. And so a lot of times our bylaws, at least the bylaws that we're drafting now, will have the ability to send electronic notices, use electronic proxies, electronic participation in meetings, which looks exactly like what we're doing here tonight, and electronic ballots. In fact, we have a statute in Oklahoma that says if your bylaws provide for written notice, written ballot, then an electronic transmission, typically an email, will count for purposes of a writing. And so in this day and age, we really should have electronic participation opportunities. And what a year ago, it was an absolute necessity. Had a lot of associations that couldn't meet, even if they wanted to. Most of them didn't, but they couldn't meet because there was nowhere to meet. Churches were shut down. Libraries were shut down. Schools were shut down. I had 4 transition meetings scheduled in March, the end of March of 2020. And we had sent notices out. We had laid all of the groundwork. We had our location secured. Well, then COVID hit and we had to cancel all of them. Well, we thought, okay, this will be over in a few months, right? So we rescheduled with the libraries where we had scheduled them, sent out note cards, and sure enough, that everything was still closed. So having the ability for people to conduct a business, whether it's a board meeting or the HOA membership electronically, is very important and sometimes crucial. Let's talk about quorum. This question comes up quite frequently. What is a quorum? Where do we find it? How do we meet it? A quorum is simply the minimum number of corporation members, shareholders that you need in person or by proxy in order to conduct business. Now, quorum applies to the board. So you have to have a minimum number of board members in order to conduct a board meeting. Typically, it's a majority. And you have to have a quorum in order to conduct the HOA general meeting. So we oftentimes find the quorum in the bylaws. Hopefully it provides something like 1/3, something fairly manageable. If it provides for a majority, what we need to look for are, okay, if we don't get our quorum on the first setting, meeting setting, is there a provision? Is there a mechanism that we can get to a quorum? The really bad bylaw language is something that simply says, in order to conduct business, there shall be a majority of the members in person or by proxy, and that's it. Usually with that, we'll want to go in and we will want to amend the bylaws to provide some kind of mechanism that the quorum lessens over time, and that time could be 5 minutes. It could be days, but preferably what we have is a quorum clause that allows us to reach quorum with a minimum amount of effort that allows us to conduct business. All right. I don't talk about this very much, but I will go ahead and mention, if you look at that bottom bullet, what the law provides, if a court orders an election, an HOA meeting, which the court has statutory authority to do, there is no quorum. Whoever shows up when a judge orders an HOA meeting, whoever shows up, that's the quorum. there is a mechanism under Oklahoma law that if there is a contested election, that any one of the shareholders, members, HOA members, can file a lawsuit and have a judge oversee the election. They will do it. They probably won't be happy about it, because this is one of those things that we should be able to at least set up the circumstances, the parameters where everyone will agree, okay, we've sent out fair notice, we've conducted a fair process, we've conducted a fair ballot count. And while I may vehemently disagree with the people that were elected, at least what I'll agree with is it was a fair process and I lost fair and square. Okay. If we can't do that, if we can't get a third party to come in and help us do that, well, then everyone can hire lawyers. Y'all can start paying people by the hour to stand in court and argue about, well, this is the notice that should happen. This is what the quorum should happen. There is a process, but people are going to spend a lot of money on something that more than likely the judge is going to look at them and think, you guys should be able to figure this out yourselves. So proxies. So speaking of elections and HOA meetings that are headed to court, where you have a board who is, and I understand most of the people on this, I'm assuming, are board members. The overwhelming percentage of my practice is advising and representing boards and serving as general counsels to the association. But when you have a board that's telling its membership they're denying proxies because the proxies weren't notarized, that's a board that either needs to be convinced of how wrong they are, they need to be removed, or possibly if they can't be dissuaded, maybe that is an instance that ends up in court. We haven't had to do that when we have a board who's taking the position that proxies have to be notarized. Look, proxies do not have to be notarized. Proxies are not an opportunity to deny members the removal process of boards that they don't like. A proxy can be written on the back of a cocktail napkin. A proxy is simply something in writing. That writing could be a text message or an email, by the way, that says, I, Matt, give Georgie my proxy because I don't want to go to this meeting. I don't want to hear what these people have to say. Georgie's agreeable to showing up in my place, and she can vote however she feels should happen. Not even how she thinks I should vote, however she wants to. And then Georgie's free to show up with my proxy and act as what's called my attorney in fact. That's all a proxy is. Okay. Now we need a mechanism to determine, is this a valid proxy? You know, if we have some kind of fact where, I had a case recently where there was a question whether an individual had gone door to door and they had a lot of signatures on what could be used as a proxy. But the question was, what were the representations? What were the statements made to the individuals in order to get their signature on that piece of paper? Was there some kind of fraud? Was there some kind of misrepresentation? You know, we're not going to spend a whole lot of time running that down. You may send an email or two. You may call so-and-so, hey, I saw your name on this proxy. I'm verifying that you want so-and-so to show up at the meeting and serve as your attorney in fact. And if what you get back is, what? I thought I was ordering Girl Scout cookies. That's what I was signing my name for. Well, maybe we have an invalid proxy and maybe we need to address that. But, you know, proxies are typically not the document to weaponize in an HOA. All right, I see a couple of chats or comments. So there's a comment about covenants for annual meetings requiring 75% to vote or from 75% to vote to the majority of the persons attending the annual meeting will carry the vote on any issue. And yes, so that's a good point, and it's a tricky one sometimes, because you mentioned the covenants being amended. And so we have to sometimes not only think in terms of, is this an HOA meeting, but sometimes we have to ask the question, what kind of HOA meeting is this, right? So if, say, for example, we have a special assessments clause that says special assessments may be adopted by a 60% of the lot owners. And then we have a bylaw provision that says a majority of the members in person or by proxy will can vote to adopt a measure or do business for the association. Well, the covenant says 60% for this particular instance, and that would be special assessments. We have to follow the covenants, as opposed to, well, the bylaws say this, and so we're going to ignore that. And so we have to really look at, okay, not only is this an HOA meeting, but what are we voting on? If what we're talking about is amending the covenants themselves, well, that's not even a corporate vote at all. That's a real estate vote. And the fact that the bylaws allow people to vote by proxy, that has nothing to do with amending the covenants, which is a real estate vote. So we have to be really careful what kind of vote there is. Another comment is, it's standard that a proxy is valid for 3 years, or what does that need to be stated in the CCRs? That's a good question and a common one. So a lot of times we won't find proxy language in the covenants. It's not that it can't be there, but a lot of times, so if you came to me and said, hey, we want you to find the proxy language in our governing documents, the first document I'm going to go to are the Articles of Incorporation. Probably not going to say anything there. The second document I'm going to go to are the bylaws. So oftentimes the bylaws will specify the proxy requirements. Now, the bylaws could say proxies are only good for a year, right? But the slide that I've got up, if you look at the second bullet, unless the bylaws provide otherwise, a proxy is good for 3 years. Okay. It's also unless the proxy itself provides otherwise. So if on my cocktail napkin I say, Georgie, I want this proxy to be good forever. This is good until I revoke it. Well, then it's going to extend beyond 3 years. Okay. Now, we don't have a case on this in Oklahoma, but I would assume that the answer, if I execute what's called an enduring, I call them enduring proxies. They're live till killed proxy. That if I sell my property and I'm no longer a member of the association, I assume that kills that proxy. That the fact that I'm no longer a title holder. But we don't have any guidance. I'm just making that up. That's my assumption. It would be helpful if we had something that says that, but that's a fight for people to take to court, I guess. Some of the questions with proxies, and you can draft it however you want. Is it a limited proxy? Do I want to give my proxy to Georgie and say, I'm giving you my proxy, but only purposes of quorum and voting for John Doe and Jane Doe? Okay, that's what we'll typically refer to as a directed proxy, or sometimes a voting proxy. Or it can be blank check proxy. It's for quorum purposes and for any business that comes before the meeting. You exercise your best discretion and tell me about the meeting later. All right. I talked a little bit about the electronic voting by email. I want to talk a little bit, this middle bullet. I call it the newspaper rule. You may call this the, you talk to your mother with that mouth rule, whatever you want to call it. This is, again, as litigation counsel, there's always this kind of nervous, anxious moment when, whether I'm on the plaintiff or the defendant side, when I get my hands on all of the exhibits. In today's day and age, it's oftentimes text messages and Facebook screenshots. I'm very apprehensive of what I'm going to find, what my board or my clients, if I represent individuals, what have they said? That can be proven either in a video, audio, Facebook, text message. Don't ever, if you're on the board, just don't ever let the things that everyone thinks, right? Things pop into our head. It doesn't mean we have to commit them to writing and send them through the internet. We certainly don't have to post them on Facebook, because I assure you, it doesn't go away. And there is a lawyer, possibly me, if I'm on the other side, who is going to find that, and I am going to make as much damage as I can to your case with it. And so the newspaper rule, or you kiss your mother with that mouth rule, is just don't put anything in writing that you wouldn't want to see in huge letters in front of a judge or a jury, right? So let me give you some examples. There are very extensive federal laws dealing with how you treat people. We all know this. We know this without there being federal laws. But there are things about the federal law, whether it's how we have to adjust how we treat people and how we enforce rules dealing with emotional support animals. This is a big one, particularly with condos, sometimes with homeowners associations. If someone demonstrates that they have a medical need, if they have a support animal, and it can be an ESA, an emotional support animal, well, then that changes the conversation. And irrespective of how a person believes the law should be, irrespective of whether a board thinks a person is faking it or not, I mean, I understand those thoughts, but we have to leave those as thoughts, because if a board puts in text messages that they think are private, if the board is sending emails to one another, man, this person is such a faker, stuff like that, it is so damaging if there's a HUD complaint filed, because those get discovered, and then it puts us in the position of having to explain, look, no, we didn't mean that. No, the things that we committed to writing, email, or whatever, they didn't affect how we treated this person. It makes our case very, very difficult. So the best thing is just don't put it in writing, okay? And besides, going back to if it were us, if we were that person availing ourselves of federal law, then we wouldn't want our board using language like that about us. So that's the middle contact there. I talked about Open Meeting Act. This is something that I think is not very well known. And that's members. A certain percentage of the members always have the right to call a special meeting, okay, under the law. Most bylaws will specify that the president of the association can call a special meeting. Oftentimes it'll say 2 or more board members can call a special meeting, but oftentimes it'll also say a certain percentage. 10%, maybe 20% can call a special meeting. So at any time, if you can convince enough of your neighbors to think the way you do, you don't have to wait to the annual meeting to re-elect a board or to throw a board out and elect, or to adopt a certain budget, or to push a certain measure, a certain percentage of the members can call that special meeting. There's a lot of those due process fail-safes in corporate law that either they don't happen because people don't know about them, or they don't happen because of apathy and, well, somebody else will have to carry that water. I'm just not interested, or I don't want to spend the time. I get that. Last thing I want to do is go door to door and collect proxies to throw a board out that I think is overreaching. But that remedy is always there. I want to talk about sex a little bit, because if you read through your covenants, particularly if I drafted them, or if the developer had a lawyer draft them and thought about these things, you're going to find some language in there that the developer puts in to protect themselves. It's no secret. Developers draft and file these covenants to protect their rights and their control over aspects of the development. And one of the ways that we do this is with this Class A, Class B. Class B member is almost always the declarant. Class A members are almost always the regular resident lot owners. If it's my set of covenants, the summary is, as long as there is a declarant, and as long as that declarant wants to control the architectural review committee and the composition of the board, well, then they're going to. Now, there are certain triggers, the passage of time, the sale of property. So if the developer declarant owns no more lots in the neighborhood, there's really no reason for, let me say, there's often no reason for the Class B member to continue to be in control. And so oftentimes that will be a transition. It's very common for us to schedule the transition, the election of the association board to the resident owners, and the declarant continue to control or serve as the architectural review committee. Sometimes people think, well, if we've transitioned the control of the association board, well, then that automatically transitions the architectural review committee. It does not under my set of covenants. It does under some developers' set of covenants, and shame on them if they didn't think about that before filing them. But at some point, we're going to see a merger of the association board and oversight, at least appointing oversight of the architectural review committee. So that's a little bit about Class A, Class B. If you come across that language in your covenants and your developer has been out of the neighborhood for 5-10 years, it's dead letter. It just carries along and is meaningless. Now, at some point in the life of the development, in the life of the covenants, there's going to be a push, an effort, or an interest to update, amend, maybe streamline those covenants. And usually at that point is when we will go in and we'll strip out all of that Class B language, all of those reserved rights, things like granting easements. We'll take all of that language out of the covenants, and that requires a covenant amendment. Of course, if the developer declarant is out at that point, you're not going to draw any objection from them, even if they could object. But if they're a lot owner, well, then they'll get a say and get a vote in that covenant amendment project. Okay, we're going to talk a bit about enforcement. I'm only going to scratch the surface of enforcement tonight. We've got 25, we're at 7:26, and there's usually a number of questions about enforcement. I may tell you, hey, we're going to cover that next week. So what I'm going to talk about enforcement is what enforcement looks like on the front end, and then next week we'll get into a little bit more detail on the types of enforcement, certainly collections, which is a subcategory of enforcement.
Matthew,
Yes, ma'am.
I just want to interrupt and say, I know you're used to saying next week, but it's not next week. It's Wednesday.
I keep saying that.
Yeah, I know. I don't want everybody to get worried. It is Wednesday that we're coming
No,
back.
that's a good catch. Yes, we've been doing this so long. I think I have caught on that we're calling it part 1 and part 2 now. I don't think I've said basics and advanced yet, which is what we used to do. Okay, thank you, Georgie. That's right on target. Next session in part 2, which will be a couple days from now, we will go into more depth on enforcement, including a deep dive on assessments, the type of assessments, and enforcing covenants. But for tonight's purposes, I want to talk about leading up to the lawsuit before it's filed, because a lot of times the question is, well, how do we sue these people? How do we get them, get them into court and win in court, and get all of our money back? And I understand that, and that is the litigation part of our practice. But what I have found is the most cost-effective, the most community effective, and I'll explain what I mean by that in a second, form of covenant enforcement happens outside of court. And it's less expensive to resolve things before you have to call the lawyer, or even when you call the lawyer, if we follow certain techniques where we don't have to file a lawsuit. Because once the lawsuit's filed, we have let go of a considerable amount of control of the dispute. One, we're putting it in the hands of a judge or a jury. So I, as counsel, don't get to say what the finality is. We've farmed that out to judge or jury. We've also handed a certain amount of control to the other litigant, because once you file a lawsuit, it's not just one way. They can turn around and do counterclaims. So if we could spend a little more time on the front end, trying not to avoid court, we're not scared of court. We know what we're going to find there. We may not know how much it's going to cost, and we definitely don't know what the end result's going to be. But we will find a mechanism that will get us to an end result. What we're talking about is trying to get people to do either what they said they were going to do, oftentimes get them to do what we think they should do, without going to court. All right. So with all of that, I'm going to show you a picture. I'm going to show you both of them at the same time, so it kind of ruins the joke. I'm not tech savvy enough to figure out how to show one and then the next. Maybe I'll figure that out, and this will be a better presentation. But all right. So here we have a royal, a gentleman by birth, right? Nobleman. And in the top picture, it looks like, he is not being a gentleman. It looks like he's using the finger that we routinely recognize when we cut someone off in traffic and someone wants to communicate displeasure to us, right? So he's flipping somebody off. But then you look at the bottom picture, and I assume, I don't know, I haven't done the research. I really don't want to know, because this suits my illustration purposes. But in the bottom picture, it reveals, okay, well, maybe we weren't looking at things from a most accurate perspective, right? Top picture looks like he's being rude, giving someone an obscene gesture. The bottom picture, he's giving them the British 3, right? And depending on where we are, our frame of reference, well, that's going to color how we respond. So the purpose of this is there are a whole host of what we call non-judicial remedies. Remedy just simply being something that gets us what we want, right? And maybe what we want is someone to remove the outbuilding that violates the covenants. Maybe what we want is someone to pay their dues on time and not generate more work for the non-compensated volunteer homeowners association board, right? Maybe what we want is someone to quit blowing up their neighbor and their board on Facebook and communicate at least rationally, reasonably, without profanity. Whatever the issue is, what I've found is it takes a lot of courage sometimes, a lot of practice. It takes maybe some deep breathing and meditation, but having someone on the board who can pause and say, all right, I know this is crazy. I know you all are going to laugh, but let's try to see all sides of this. That's a very good exercise to go through. It's a great exercise for the board, for someone to say out loud, okay, do we really believe that the purpose of this association is to promote community, and that we treat our neighbors the way we would want to be treated? Is there something more to this that we need to figure out? Is there an opportunity to learn more about the situation that maybe will color our response to what we perceive as a covenant violation? I'll give you the worst example from my practice so far. I hope it remains the worst because it's embarrassing to me. So, individual in a neighborhood, Oklahoma City, I have a very close developer client that I've known, I've learned so much for. He is a client, but he's a friend now, a guy whose relationship I value. He contacts me, says, hey, there's this covenant violation going on this lot. We've tried to contact them. They've been unresponsive. And so the next step in the process is for me to send a demand letter. I do. And then I find out that this individual has recently lost a spouse and has been out of town, focused on other things. And that's the reason why I think it was a trash can. Trash can has been sitting out forever, right? We could go through well, how hard is it to just pull your trash can in? How much time does that actually take? And, you did agree to the covenants just like everyone else, and everyone else has things going on in their life, but they seem to manage to get the trash can in. We could take that perspective, but I'll tell you, as soon as we found out what the circumstances were, we both wrote her an apology and told her, look, we are so sorry that you received this at this time, and essentially you let us know when it'll get taken care of. We could have taken a very different approach. Some people might argue, put the screws to her. Who cares whether she just lost a spouse? She's subject to the covenants just like everyone else. And you would be absolutely right. But that's what people do in commercial settings. Business can be cutthroat. Our association business should not be. And so what happens in those situations is there should be a neighbor or a board member, or me, if I have the opportunity, I'll go take the trash can and pull it up off of the curb, because that's what neighbors do, right? So having the space, the comfort to enforce our covenants with kindness sometimes, and I know people don't want to hear that from their lawyer. They want their lawyer to be flesh eating and to rip the skin off the opponents and not just enforce the law, but really grind it in. I get it, and there are those lawyers out there, but that's not community association law. That's not good community association board governance, at least in my book. And by the way, whether it's a collections action or a covenant enforcement action, the goal is for that person to do what you want them to do. That's persuasion. And we all know people are much more persuaded when they're treated humanly, when they are extended a little courtesy, maybe a little dignity. You can get people to do what you're making them to do, just like you can get children to comply with the rules, but the relationship can be damaged. You will get behavior, but you won't get community. And so taking an approach of, can we help this person see our side of things, and can we persuade them to do what we want them to do? Those are fantastic non-judicial remedies, right? I want to look at this bullet. Don't want to belabor the point, but getting ready for difficult conversations. We spend a lot of time, I won't say we, I spend a lot of time. I spent a lot of time watching Netflix. I think everybody else in America did. I spent a lot of time on the things that I enjoy doing that I want to be really good at. I enjoy fly fishing and I practice at it. If we applied those kinds of principles to our conflict resolution, your association would pay much less in attorney's fees, and you would see a dramatic increase in people's perceived community, the level of community in your neighborhood. I can't map out exactly what that looks like, but some of the elements are practicing in front of a mirror, thinking in terms of tone, thinking in terms of gender. If I need to have a difficult conversation with someone of the opposite sex, cornering them as soon as they get out of their car in their driveway is probably not the best approach. Asking permission to come to someone's house and inside their home, not hat in hand, not crawling on the floor, but on a footing where they feel comfortable, where they don't necessarily need to feel defensive. And I can have this conversation about, look, I'm a volunteer. I am doing this because I want to serve my neighbors. And some of your neighbors are complaining to me, and I'm here wanting to figure out how I can serve you in this. Saying stuff like that out loud, at least for someone saying that to me, it's not disarming, it's humanizing, and they're not there to take a piece of me. They're there trying to figure out a problem and involve me in the solution. That kind of stuff doesn't naturally come to me. I mean, I think in terms of adversarial debate and conflict, and so I have to really work at that. But when I do, I usually see the conversation either going exceptionally better than what I anticipated, or at least we can get down to the nitty gritty and the person can, look, this isn't going to change my mind. My trash can is staying exactly where it is, and these are the reasons why. Okay, great, understand. Thanks for giving me the opportunity to hear your reasoning, and maybe this is something that we need a third party or a judge to decide. All right, a couple of comments. Okay, yeah, just reiterating that. And by the way, because those kinds of conversations, that form of communicating does not come naturally to me, if you leave me to my own devices, I'm going to get it wrong, oftentimes. But if you put me with people who I work with, volunteer with, that we spend time talking about this stuff, if I have someone say, now, remember, Matt, don't jump out of the bushes and accost this person on their driveway. And why is your trash can, remember, Matt, that doesn't work too well. Man, is that helpful. And this is why we do governance together, why we do governance as a board and not dictators. because we have a body of hopefully very, very diverse people, whether it's backgrounds, socioeconomics, education levels, genders. We want as much diversity as possible on that board, because that's where all possible voices are going to get heard. Okay. And it's most difficult, I find, where those minority voices, that it's real easy for a majority, and I'm not talking about the typical minority, I'm talking about where you've got a group of majority on a board, and there's that, well, what about this idea, that kind of minority. Having a group of board members who embrace listening to that minority, even if, hey guys, this may be off the wall, but can we consider this, or at least can we talk about this and dismiss it so I don't have to think about it anymore? That's a highly functioning board. Let's see, got. All right, question, when your covenants state empty lots should be developed within 12 months after purchase and years go by and the lot is still vacant, what is the HOA recourse? The owners are paying HOA dues on time and keeping the grass cut on the empty lots. Okay, so as I understand it, the individual owner has a lot, they're cutting it, they're maintaining it, they're paying their dues. I'm not clear on what recourse should happen. There's nothing. Oh, it says the covenant state empty lots should be developed within 12 months. Well, this is one of those, we'd have to look at the exact covenant language. It's a little unusual to have a covenant that says I have to build something within 12 months of purchase. It's not that there couldn't be a covenant to that effect. Oftentimes there are time limits, but it's not tied to ownership. It's tied to when your plans and specs are approved. It's really common to have diligent construction until completion covenants. It's a little unusual to say you have 12 months to build on this vacant lot. So I think we'd have to look at the covenant language and understand exactly what it means. And even if it does provide building 12 months from the date of ownership, we'd have to look at what would be the purpose of enforcing that, and what would that covenant enforcement look like? Are we going to take this individual to court and stand in front of a judge and say, hey judge, we have covenant language that says they have to build within 12 months. It is highly unlikely, possibly impossible, for a judge to order someone to build a house. Now, again, where we do see this sometimes is if somebody submits plans and specs, they get approval from the Architectural Review Committee to build it, they start construction, and then they stall out, they stop. Now, I have enforced a continue construction until completion clause, but I think it'd be very difficult for a judge to say, well, we have a covenant that says you have to build it, so get started. That's going to be difficult to enforce. This also raises a question, and I understand this and I get this from time to time from boards, is they have an issue that's directly addressed by the covenants, and we could use this as an example. And so because the language is there, and because we have a technical covenant violation, the board feels that they have to enforce it. But we might ask the question, what is the purpose of this covenant? And do we even want to enforce it? Do we want to spend tens of thousands of dollars on litigation to enforce this no vacant lot covenant Or do we want to amend that language out? If we make the determination, it's not going to hurt our property values if this lot remains vacant. In fact, they may be speculating, and they sell it for a higher per square footage that they bought it for, and increase comps. So boards should feel free to look at this and say, I don't know what the purpose of this is. I don't know if it furthers our sense of community or property values to enforce this, and then put it to at least a straw poll, get some feedback from the membership that, hey, look, we have this covenant, we have this fact. Do we want to move forward with this? And not pawn the decision off on the members, but get some feedback so that the board has some good wisdom from the members of whether to move forward. All right, next one, we have one resident who routinely doesn't pay annual dues until lien notices are sent, and dues still are not paid for 2021. Late notices were sent. The board has not contacted them about the delinquency due to the sensitivity of financial issues. Okay, I don't know what you mean by sensitivity of financial issues. You could mean we don't want to pry. Maybe they're having financial difficulties, and that is right on target. Making the assumption that someone isn't paying because they're having difficulty making ends meet, and realistically, what we find is that the association is the last creditor on the totem pole that people choose to pay. I get it, understand it. I also understand that you make the choice to pay your dues on time in the right amount when you buy in a neighborhood, with a mandatory community association. So a lot of times what we'll find in these instances where we have delinquent owners is we have to be sure to have a clear collections process, and that collections process starts before that individual takes title to their property. The collections process, and we go into more detail. I started to say next week again, Georgie, but in a couple of days. We'll go over the collections process in part 2 in more detail, but it starts before closing when the title company asks for a closing letter and provides some notification. But it sounds like what could happen in this instance, an individual board member or management company, if there is one, could go to the individual and inquire, shoot them an email, check on them, make sure they're okay. And if possible, if needed, enter into a payment plan so that they don't get behind, so that a lien doesn't get filed. And that's treating a neighbor in the collections process the way you would want to be treated as well. We have a very specific collections practice. Have a person in my office, an attorney, that's all they spend their time on is HOA and condo collections, and we will spend much more detail on that in part 2. I have very particular opinions on condo and association debt that I'll share with you. All right, what is the best way to protect the association when you have 2 runoff ponds right next to a school, and the children continually walk onto association property by the ponds and actually get in or fish out of the pond? There's a lot that goes into addressing potential pond liability. And so just for time purposes, I will throw a few things out. One of the things is your association has to be incorporated. 2, there has to be insurance in place over liability. Putting up signs that prohibit trespassing, putting up fences, those are all pretty common techniques. If what we have is kids bypassing fences, trespassing, then maybe we would need to look at contacting the school or possibly law enforcement, look at a layering effect. And and addressing it that way. Okay, let's talk a little bit about records in our time left. We got 9 minutes and we should be right on time. Spend the rest of it answering any additional questions, but records. All right, so I mentioned earlier that in Oklahoma, if for incorporated associations, there is a statute, it's Title 18, Section 1065, that if you read it, it may not seem like it applies to your corporate homeowner association, but I assure you it does. It uses language like shareholder, even though you don't have shares in an HOA, but it applies, okay? And so this is how it works. If an individual member of the association asks to see the books and records of the association, the answer is not no. The answer is possibly, okay, well, what are you wanting to see? And we can possibly direct you to the website, or possibly the management company has them on their website, or maybe you can get them from the lawyer. Sometimes people want copies of the governing documents. Well, I said I have a complete governing document set. It's really easy for me just to email that. I would put the overwhelming percentage, if there's a records request, it's because an individual has been told no, or it's because an individual has been told it's really time for you to pay your dues. It's usually done in retaliation, and that's infuriating to boards, and oftentimes it produces this, well, we know you're just doing this to be a jerk, and so we're going to tell you no. But boards have to fight that urge, right? The jerks get access to the books and records just like the non-jerks. So one of the things that we can do with books and records is anticipate this. We call this driving conversations into a corner. We drive them into corners because maybe we need to kick it to death in that corner. We drive it into a corner because we don't want it to get out of control, and we want to try to manage that conversation. So the way we do this with records is you put all of the governing documents, you put all of the meeting minutes, you put those in a place that's readily available to the members, because those are going to cover a lot of the questions that people have, right? Well, can I paint my house pink? Well, here's the books and here's the governing documents that deal with what you can and can't do with your property. So one of the things that board members really need to know is 1065 and records request does not include answering every member's question when they demand it. And a lot of times when it comes in, can I paint my house pink? They may not be phrasing it properly as a records request, but that is a question the board doesn't have to answer. If you want to paint your house pink, there's a process to go through architectural review committee. Here's an application, or here's the form that we use. Here's how you submit it. Yeah, but can I paint my house pink? I can't answer that. We can't answer that. We can direct you to the governing documents, and we can show you the process, the very easy to use. We've provided you the form process to answer that. How much did the association pay the lawyer last year? And why are you paying him all this money? The board does not have to answer that question, because those questions can be addressed by the books and records that are freely available to the individual owner if we've put them available online. So having secure websites where we put all the bank statements, the reconciled bank statements, man, those conversations go to the corner, and that individual can spend as much time as they want. The board does not have the obligation to answer every question that comes to a member's mind. The board certainly doesn't and shouldn't answer everything that seems to pop up on Facebook. And I understand the difficulty there, particularly if the accusation is, where's all of our money going? I think the board's stealing it and spending it on themselves. Facebook is not the place and it's not the board's obligation to respond to garbage like that. Okay. There are tools, techniques, methods to try to manage those kinds of conversations. But if you're like me, the first thing to manage is my head exploding and me wanting to, retaliate and set the record straight. Very little good ever comes from that. It's also not the board's obligation to provide copies of those documents on demand. The 1065 request is an inspection and identification for copying. A lot of times these records requests, particularly if they're just for harassment, they try to get the board to jump through hoops or the manager to jump through hoops. That's not how it works. That individual has to have skin in the game. They can't just fire off a demand. They have to inspect if they want a copy, and they inspect and identify. Now, on the converse, I find boards using records requests and hoop jumping as a means to punish individual owners, and we can't do that either. When we do litigation with a records request component, I try to avoid them at all costs, because every judge that I've been in front of, they're very angry when it comes to having to parse out whether this book or record was made available, should it, how, all of that. What we want to do is be able to present a record that, Judge, on the front end, we did everything that we possibly could to make these freely available to the membership. We made reasonable requests or inquiries to this individual. Just tell us what you're looking for and we'll pull it ourselves and send it to you. But we don't have the obligation to answer questions. Why are you doing this? What did you spend on this? We just make those records available. They can identify what copies they want. And then we can charge them for those copies. When I say freely available, the association can charge for copies, but a lot of times we're going to scan and digitize the books and records anyway. And so if it's no cost to the association, if it's no skin off their nose, then we just simply burn it to a flash drive or put it to a flash drive. If you look at section 1065, and I realize we've just got a couple minutes left, 1065 requires the owner to provide a proper purpose. A proper 1065 request too has to be under oath, which means notarized. The proper purpose, if you look at the cases, and there's only a handful in Oklahoma on what that means, they're very expansive. So sometimes boards get defensive and say, well, you don't have a proper purpose to get access to the books and records, particularly if that request is, I want access to the ownership list, names and addresses, and I want access because I'm gonna send everybody a letter telling them how bad I think this board is and how I think they're abusing their power and wasting our money. That is a proper purpose. It's a purpose we may not agree with, and a purpose that we certainly would like to prevent, but under the law, that is a proper purpose. All right. Comment came in about emailing minutes, and those minutes including financial activity and delinquency line items discussion. The very last thing, and we're at 8 o'clock right now, but if you think of things over the next couple of days, feel free to ask those questions in part 2 and we'll cover them. But the last thing that I'll cover in terms of books and records, when is it okay not to produce a certain book and record? Well, there are certain records that we don't produce. Itemized attorney invoices. Most attorneys like me, when we bill, we don't write a novel, but we write detailed invoices of how we spent our time. And reviewing those emails, or excuse me, reviewing those invoices could reveal very specific legal advice and the deliberative process, counseling process that goes on between an attorney and a board. So oftentimes we will not provide detailed invoices. Now, we can provide statements. If the question is, how much did we pay an attorney last year? Well, we can provide that. They're going to get that in the bank statements with the checks to the firm, but not the invoices. Another thing that we don't allow, and this sometimes comes up, can we publish the names of the people who are delinquent in order to shame them into paying their dues? The answer is no. Well, you can, just probably is going to draw a lawsuit. And there's no reason to do that. But also with records requests, we will redact or not provide information on who's delinquent on their dues. There's no right of privacy. This is simply an HOA protection thing. So that's a little bit about books and records. If there's more questions about that, then we'll cover it next week. With that, we're going to wrap up for tonight. Have a good couple of days, and thank you for spending the last couple of hours with us.
I will say thank you very, very much for Matthew, and we will see everybody again on Wednesday night. It is just day after tomorrow, not next week, day after tomorrow. It's a very fun-filled, I don't know how fun it is, but it's a very information-filled night. The second night it's information that you will use every day in your HOA, because it really is a lot about covenants and enforcement. And thank you, Patrick, for sponsoring the workshops as well. We are recording. I forgot to tell you that at the very beginning, but we do record these, and you will have access to this recording. So if you have board members that weren't able to attend, you will be able to show them this recording as well and have this for your information to be able to go back and look at as well. So thank you all very much, and we will see you back again, same time, same channel, Wednesday night. See you then. Bye-bye.